heard me say this before. Divorce boils down to the money. Look at the Kevin Costner divorce. The latest headline is Costner's estranged wife is allegedly requesting $248,000 a month in child support. Again, money. For couples, even same-sex couples who are facing divorce, there are a lot of financial factors they need to be aware of so both sides get what they're entitled to under the law. That's why having a certified divorce financial analyst can protect them on so many levels. Joining us to explain is the program's regular contributor, Donna LaScala. Donna is president of Comprehensive Divorce Solutions in New York. Donna is also a certified divorce financial analyst, a registered financial consultant, a financial neutral, president of the Long Island chapter of Financial Planning Association, and board member of the Association of Divorce Financial Planners. Donna, welcome.
Very nice to be here.
Always nice to have you. So why is it crucial for same-sex couples, and again, we are devoting our attention to that in honor of Pride Month, to retain a CDFA during a divorce action?
So during a divorce action between a same-sex couple, it's so important for them to work with the CDFA because they have to understand that the standard approach to division of assets often does not apply in these cases. So what do I mean by that? Division of marital assets assumes two demarcation points, the date of marriage and the date of separation, to define what has been accumulated during the marriage and naming it as marital. The issue for same-sex couples or any couple that's been in a long-standing relationship other than a traditional marriage is that there are assets and debts that could have been accumulated during the time before the legal marriage date that should be taken into consideration. So now, at this time that they're separating, they have to think about, well, how long have we been together versus how long were we actually legally married? And if there's no form of recognized legal joint ownership established, it gets very tricky when discussing separation of those assets and debts when you're talking about divorce.
What is the Majauskas formula, and why is it important for same-sex couples to get educated on if they decide to file for a divorce?
Okay, so a little history. The Majauskas formula was created as a way of determining joint ownership of pension assets specifically. In 1984, the New York State Court of Appeals heard a case, Majauskas v. Majauskas, where the wife had claimed that she was entitled to a portion of the husband's pension from the Rochester Police Department. So the husband had argued that because he started work prior to the marriage, she wasn't entitled to anything. The court actually agreed with the wife and ruled that she was, in fact, entitled to a portion of the income from the pension and created what we now know as the Majauskas formula. So this formula looks at the amount of time a person has been employed versus the amount of time that they've been married. And it comes up with something called a coverture fraction. That fraction is then applied to the total amount of the cash value of the pension. The marital portion is established by another formula, and then 50% of that amount is awarded to the non-participating spouse. So let's think about that. If you're dealing with a same-sex couple, you can see why this would present a challenge, because the length of the marriage is a key component to the formula. And for a same-sex couple, they may have been together for 20 years, but they may only have legally been married for 10. So according to the formula and according to the traditional way of looking at this, only the 10 years of legal marriage would be taken into consideration for the calculation of the marital portion, making the other spouse ineligible for a large portion of income from that pension.
Are there different types of joint ownership when it comes to the financials? And if so, can you explain what they are?
Yeah, absolutely. So there are ways that you can establish joint ownership between individuals, even if they're not related by blood or by marriage. And those two ways are commonly joint tenants with rights of survivorship or joint tenants in common. So these designations can be used for things like real estate, for a bank account, for brokerage accounts, but they can never be used for retirement accounts because retirement accounts cannot be jointly owned. So, for example, Ilyssa, my dear friend, you and I could be joint owners of a house. We could be joint owners of a brokerage account. We could be joint owners of a bank account, even if we're not related or in a relationship that is legally recognized in some manner. As long as we have established that this asset is jointly owned equally by each of us, we are each entitled to 50% of the asset. Now we get back to retirement assets, a 401k, a 403b, an IRA. These can never be jointly owned. And this is where it gets tricky again for same-sex couples. A retirement account that was established 20 years ago in 2003, while they may have been in a committed relationship but not legally married because the Supreme Court did not recognize marriage until June 26th of 2015, the other party has no legal right, as recognized by the court, to the money that was accumulated prior to the actual date of the court-recognized marriage. So that's 12 years' worth of contributions, employer matches, and growth that the non-participating spouse would not be entitled to according to the law. But if there were other assets, like a bank account, like a house, like a brokerage account, that they had done tenants in common or joint tenants with rights of survivorship, they would be legally entitled to those assets.
Yeah, and you just talked about the law, and in New York, where you and I are both based, the law does state that this state is what's called equitable distribution. So why can the mediation and or collaborative process, which I know you play a big role in, help same-sex couples when it comes to exactly what you were just talking about, dividing the assets?
Okay, so here's the good news. When I'm involved as a CDFA in a mediation or a collaborative divorce process, we can look at extenuating circumstances when discussing equitable distribution of assets. So we can calculate the amount of money that was accumulated before the legal date of marriage, back to 2015. So we can go beyond that. And we can add it back into the potential marriage pool to make it more representative of the couple's actual longevity of relationship. If this is what works for the couple, and then this is what's better for them, it's a better way of handling the situation, not according to what would be prescribed by the court. So we can make it more equitable and more representative of their actual relationship and intention for each other after divorce.
And by doing that and sitting down in a mediated or collaborative process, that also saves a couple a lot of money.
Oh, absolutely, because they stay outside of the court system. They're not subjected to the court's calendar. They can get everything done with a mediator or through the collaborative process and then file the paperwork with the court. So it does save a lot of time if they're willing and amenable, and it does save them a lot of money, again, if they're willing and amenable, because they have to be involved in the process and have to want it to go smoothly.
Donna, for people who want to get in touch with you and continue this conversation, how do they do that?
The easiest way, 516-234-7522.
Comprehensive Divorce Solutions. Thank you so much for joining us. Don't go anywhere. We will be right back after this break.
At Comprehensive Divorce Solutions, Donna LaScala provides the tools for people to deal with assets, debts, equitable distribution, and retirement in divorce negotiations. We hold your hand during and after the divorce process, providing a roadmap of what happens next and into the future. Divorce is difficult whether you're initiating it or not. It's fraught with emotion. When you deal with emotions, you are not dealing with logic, making it more difficult to decide what to do with your money. Hiring a professional to assist you in walking down the money path is crucial to avoiding potentially costly mistakes. Donna's goal is to make sure that each individual knows how they are going to be able to survive and thrive during and after divorce. As a CDFA-trained mediator and collaborative financial neutral, Donna helps people get unstuck and move forward towards their post-divorce future. Call Donna LaScala at 516-218-6919, 516-218-6919.